To further break down this breaking news, I want to bring back in Seth Berenzweig. And Seth, you were being handed the same ruling that I was live on Live Now from Fox. This is raw. This is unfiltered. We are covering the news as it happens. We did let you take a look at this. So I want to know now, I mean, you've had just a few moments. It's a thick document, but from what you've been able to read, what have you gleaned from this?
Well, thank you for letting me have a couple of minutes. Reminds me of those old commercials in speed reading. I feel like I've got a pretty good handle on it. Now, of course, many constitutional scholars will be digesting this all weekend, but here's what I discern from the decision. First of all, from a high-level standpoint, it's very dense because the Chief Justice in a 6-3 decision provides the decision for the majority. And what he's basically doing is he's saying, look, there are certain zones of presumptive executive immunity, and you can think of it like playing darts in a bar, right? So you have the red target in the middle, and then you have things that kind of go out from that zone peripherally. What the Chief Justice did, which I believe is a big win for former President Trump, is he created a limited zone of absolute executive immunity. What he said is that if there are actions that a president takes that relate to communications within his executive lane, and specifically with the United States Department of Justice, those communications are going to be subject to executive immunity. You cannot attack those communications. You cannot admit evidence of those communications. You cannot go into his allegedly corrupt motive regarding those communications. There is a complete zone of core protection with regard to things that would fall within his communication lane. The problem with that, one could argue, is that under the allegations, President Trump didn't just go into that lane. He drove a bulldozer right down it with a plan of corruption. Again, we're just talking allegations here, of course. But what the court did, and what infuriates the dissent, is that they are providing a core zone of protection with regard to communications between the White House and the Justice Department, which is a win for the president. But in the essence of some constitutional baby splitting, what the majority then says is, as you go further outside of that red dot, out of that core red zone, and as you get further towards the periphery, for example, pressures placed upon the Vice President of the United States relative to the actions that he was going to take in the halls of Congress, and then even further outside of that zone, for example, communications with other officials who are state government officials in Georgia, for example, that certainly do not fall within the executive federal lane, then those are things that would not be subject to executive immunity. So what the court did is it created basically a varying bullseye, let's call it, where it provided some very slick constitutional baby splitting. Some things that are in the core, President Trump got a real big victory today. Things that slowly float outside of the core. What the court did then on page 28 of the opinion is it said that as you get further away, there has to be a determination on a remand to Judge Chutkan in the district court below for a determination of where to draw that line. And then I read very briefly in relevant part, the concerns we noted at the outset, the expedition of this case, lack of factual analysis by the lower court, and the absence of pertinent briefing by the parties thus becomes more prominent. We therefore remand to the district court to determine, in the first instance, with the benefit of briefing we lack, whether Trump's conduct in this area qualifies as official or unofficial. So what that means is, hey, Judge Chutkan, you're on. You're in front. You're back out on Front Street. This case is yours. We're going to vacate the Court of Appeals decision. for not providing a more thorough analysis of getting into the weeds. We're going to remand it down to the district court. We're going to have briefing on what is inside and outside the core lane of executive power. And then that is going to lay the evidentiary lines and rules for a trial that can take place. And some lawyers would call that a motion in limine, by the way. This is not something that is very foreign. It's not unusual for lawyers to file briefs in advance of the trial to determine what's fair game and what's not fair game. So I would argue that there's a lot of this that makes a lot of sense because you have procedural certainty and clarity going in. I will grant you it's a very dense opinion, and the dissent is absolutely furious because they're saying you are creating a core zone of protection. He can do whatever he wants with the Justice Department. Give me a break. But we have a line. It's a little bit of constitutional baby splitting, but that is essentially the essence of what we have. We're going back live to Judge Judkin in the district court. It is possible, not clear, but possible that she can get this case activated right after the 4th of July weekend.